and what we know so far, which is not as much as you would expect, but we'll talk to you about that as well. So that was
Okay.
If you can't hear me too, or Alyssa, just let us know and we'll speak up, okay?
Before we look into West Virginia law specifically, we need to spend a few moments focusing on cannabis from a national perspective. The reason for this is because the use of marijuana is still illegal under federal law. Only one state, Idaho, has yet to address marijuana and whether it is legal recreationally or medically. We will discuss West Virginia law and federal law more in a moment.
So the first thing, Alyssa touched on this already, but under the federal law, under the Controlled Substances Act, marijuana is a controlled substance. It's a Schedule I drug, and you can see here that it's listed along with heroin, LSD, ecstasy, and some really hardcore drugs. Kind of one of these things is not like the other, right? And so as we've learned more over time about marijuana and its benefits and its risks, states have started loosening their hold on their regulation of this drug as something that is treated the same, say, as heroin. In 2013 said, federally we're not going to prosecute crimes against marijuana, but then when Jeff Sessions took over, he was like, well, we're going to start treating marijuana like a scheduled drug again. And now we're back with William Barr, who has kind of lessened the enforcement action federally as it relates to marijuana, so long as the states have a program in place. So if a state like West Virginia has a medical marijuana, medical cannabis program, feds aren't going to look at that. If you're in Idaho and you're using marijuana, there's no program, then the feds are going to look at that more seriously. So with that, we'll talk just a little bit about the public perception of this issue.
There was a survey done in April of this year, of 2021, and it's a snapshot of the national public opinion regarding the legalization of marijuana. So as you can see from this pie chart, the overwhelming majority of people of those surveyed believe that marijuana should be legal from both a medical and recreational perspective.
All right, so Alyssa already touched on this a little bit, but we have a chart here that talks about, what states have exceptions for medical marijuana. Those are the ones that are in, let me see here, I don't have the colors. Medical use permitted, so they're like the dark purple. And then we have states that have recreational use, of the pink. But Idaho is the only one that hasn't come around the bend, so to speak, in terms of opening up usage of marijuana in some regard. So you can see, I think we all remember back in, I think it was 2012, when Colorado was the first state, and it was like a really big step and a really big deal. And just in the last 8 or 9 years, we've come pretty far in terms of what the states are doing with regard to usage of cannabis. The other thing that I want to talk about when we're looking at this slide is that the states are pushing the envelope even farther. So it's interesting, we'll talk about this in more detail, but some states like Connecticut, Illinois, Montana, New York, and New Jersey have put into law in the last year that employers can't punish their employees for off-duty usage of marijuana. So that is also just like a protection that's going even further than some of the things we'll talk about now. And Nevada and New York City just passed some legislation, interestingly, that you can't do pre-employment drug screening for marijuana. So I think we're going to continue to see this trend where the states are going to sort of liberalize the usage and there's going to be less control for employers, but we'll just have to kind of keep watching that. Later was involved in a workplace accident, and as their policy allowed for, the employer drug tested, because there's a lot of workplaces, many workplaces do post-accident testing. And so the employer did that, and he tested positive. The employer terminated his employment, and he sued, basically arguing that because he had this medical marijuana card, he shouldn't have had to pass the drug test. And so what happened in that case is that and this is back in 2018. So the federal court in New Jersey basically said the statute doesn't require employers to waive their right to test and then make employment decisions. And so that was a really employer-friendly decision. You know, we like seeing that because it still gives some control to the employer. Of course, if there's an accident, you want to be able to discipline employees because you want to also be able to dissuade employees from coming to work impaired, right? And having accidents where people are hurt. So that's the first case. We'll then talk to you about the case from New Mexico.
Yes, the second case listed up there is a case from 2016 from a federal court in New Mexico. And in that case, an individual had HIV and AIDS, and he told his employer during his interview that he had a medical marijuana card for a disability. His employer hired him anyway, knowing that he had a medical marijuana card. Upon the start of his employment, he was drug tested. He tested positive during that drug test, even though his employer knew he had a medical marijuana card. His employer discharged him because he failed a drug test. In that case, despite having a medical marijuana card and despite his use being lawful under state law, the employer found that the court held that the employer did not have to accommodate his disability, did not have to accommodate his medical marijuana use.
But in that case, there was a young woman who worked for the employer, and she told the employer, "Hey, I'm getting a dispensary card." You know, she wanted to become a dispensary, and well, not she, but she wanted to open a dispensary, and the employer disciplined her for performance issues, and then ended up discharging her. And she filed suit under the act in Maine, saying that she was basically discriminated against because of her involvement with medical cannabis, and that the statute authorized her to be a dispenser, to open a dispensary, and so that the employer should not have been able to fire her for that purpose. In that case, the court basically said that, you know, the employer can do what it wants, that the statute didn't provide for that kind of a cause of action, that, you know, she couldn't tie her conduct to a protected activity. And so again, these are all cases that were really good for employers, and we were very excited to see that, you know, the courts were coming down in a way that would protect employers in making decisions about their workforces. A more recent case is the 2019 case out of Arizona, and it involved an employee from Walmart who had a medical marijuana card. Now, she suffered a workplace injury and then failed the drug test, post-accident drug test, and was fired. In that case, the court found that there was no evidence that the employee had used, was in possession of, or impaired while at work, or that the use of medical marijuana caused the accident. And so the court decided that it did violate Arizona's anti-discrimination provision of its Medical Cannabis Act, and found in favor of the employee. So you can see the sharp divergence from where we just were, right? We have an employee who's actually injured at work, tested positive, and the courts are saying, yeah, but she didn't look impaired, she wasn't using it on the job. The fact that she tested positive is not enough. And so the employer then lost that lawsuit.
So now we're going to go through a different factual scenario. In this case, there is an individual who was offered and accepted a sales position with an employer. This employer had Crohn's disease, which is a serious medical condition. She was told that she'd have to take a drug test by her soon-to-be supervisor. She explained that she had Crohn's disease and had a certification qualifying her to use medical marijuana orientation and her first day of work. The employer got the positive drug test result and discharged her because it followed federal law and not state law. What do you think happened? Was her discharge lawful or unlawful?
So this case was one of the first cases where we all took a collective gasp, because Massachusetts did its own thing and basically said, you know, this is off-duty conduct. There's no indication that her usage was impairing her ability at work, and that we don't have the ability as employers to regulate off-duty conduct, which is not terribly surprising because that's true in other contexts as well, but we're talking about drug usage and drug usage in the workplace.
It's a copycat state. We adopted in 2017 the West Virginia Medical Cannabis Act. We adopted it almost verbatim from the Pennsylvania Medical Cannabis Act. It was adopted a year earlier. The West Virginia Medical Cannabis Act creates a program in which individuals can apply for a medical marijuana card. It also permits practitioners and physicians to be able to give these cards to individuals who can then take the cards to dispensaries and get a 30-day supply for medical marijuana. However, although the act was passed in 2017, the program is still not up and running yet. And in the meantime, the West Virginia Senate attempted to pass changes of the West Virginia Medical Cannabis Act, but the bill died in the House. So these attempted revisions in 2021, which are not currently active, include the following. There was an increase in the list of serious medical conditions from 14 to 56. The attempted revision was to allow dry leaf, plant, and edible forms of medical cannabis. There was also an attempt to pass a compassion certificate. This would allow a patient or caregiver to lawfully grow up to 12 cannabis plants and up to 12 seedlings until there will be a sufficient amount of medical cannabis to meet the demand for medical marijuana. But the program will finally be in operation in late 2021, and soon we will see medical marijuana be in action in West Virginia.
So where we're at right now, there are 10 growers and 10 processors in the state, and you can read what's written there. The plants are in the ground right now. They're getting ripe for dispensation. There's a cap of 100 dispensaries statewide. I think the legislature was trying to keep this program small, at least to begin with, to really regulate it. But we should be starting to see those opening here soon. The patient application and the physician applications opened, and you can see here we had 2,000 patient registrations as of the time that this slide was created, and 58 physicians who had signed up. One of the things that I thought was really interesting is that the physicians will be able to prescribe, or recommend, not prescribe, by telehealth. So we're going to be in a situation where people don't even have to go in and get a physical exam, but they can get these recommendations.
In February of 2020, Morgantown City Council unanimously voted in favor of an ordinance to change marijuana possession penalties. So under state code, individuals who possess marijuana can receive between 90 days and 6 months in jail and for a fine of up to $1,000. But under this ordinance, the Morgantown Police Department has the authority to only fine $15 for possession versus $1,000, and no jail time versus 90 days to 6 months. Interestingly, the ordinance only applies to the Morgantown Police Department. So West Virginia University Police, the Monongalia County Sheriff's Office, and the West Virginia State Police can still charge an individual who possesses marijuana under the current state or federal law, which does impose harsher penalties.